This is Duke University.
Good afternoon. Welcome to the 9th Annual Frey Lecture in Intellectual Property. I'm David Levy. I'm the Dean of the Duke Law School. This lecture was established in 1985, was established by our 1985 graduate, Kip Frey, and his wife, Meredith. Kip is not with us today, unfortunately. He had to be out of town, but he's had a most interesting career in law and in entrepreneurship, and he is one of the primary instructors in our new LLM in law and entrepreneurship here at the law school. His dedication to the law school and to creativity and collaboration in the field of intellectual property and innovation is underscored by his support of this lecture series. I thank Kip and Meredith. Each year, the Frey Lecture brings a distinguished thinker, scholar, or practitioner to the law school to discuss issues related to intellectual property and innovation. But this year is special and unique because our Frey Lecturer is already at the law school. This is the first time that our very distinguished faculty in intellectual property has asked one of its own to give the Frey Lecture. Professor James Boyle has the honor of introducing his colleague today, and I have the honor of introducing Professor Boyle. Professor Boyle is the William Neal Reynolds Professor at Duke Law School. You know, we often sometimes describe people as brilliant, and we probably do that a bit too readily, but Professor Boyle really is a brilliant teacher and scholar. He is a leader in the study of the public domain and directs Duke Law's Center of that name. He is a founding director of Creative Commons, which works to open access to art and cultural materials. His most recent scholarship asks us to think about how the law will treat artificially created entities, I think he means sort of people, that have some but not all of the attributes we associate with human beings. His books and articles are path-breaking, and of course, they are always freely available on the web. Professor Boyle.
Thank you, David. Thanks also to Meredith and to Kip for making this possible. I have been duly credentialed, and so I think I am a sufficiently credentialed person to introduce my dear friend and colleague, Arti K, who is giving today's lecture. As a speaker, my preference is for very short introductions. As a person giving an introduction, I find my preferences are entirely different. The description of this lecture was written with Arti's characteristic modesty. As a result, there are certain elements of it that might seem perhaps dry or might not immediately leap off the page as being as important, as vital, and as exciting as I think you will actually find it. And so I'm just going to give a slight pitch, both for Arti and for the lecture, to frame what she's going to do in a slightly larger context. In the 5th century AD, the Chinese finally perfected the horse collar. Up until then, horses had had a variety of yokes, which had the slightly unfortunate effect of choking them when they pulled hard and also did not distribute weight. The horse collar was a revolution. It enabled an incredible surge in productivity. It made fields that could not have been plowed before available. It allowed horses to be more valuable, more productive than oxen. It was innovation. You are sitting here with thousands of years of innovation like the horse collar behind you. Innovation is important. Second point, innovation is also very hard to get right. We all have strongly held intuitions about innovation. We think maybe if we have more intellectual property rights, there will be innovation. Or maybe there are too many intellectual property rights and we should have fewer. Maybe the government needs to fund basic research, or maybe we need to commercialize that research immediately. Those intuitions, strongly held, frequently are at odds with the facts. And so what we need is a scholar, a thinker, somebody who actually is humble about our ability to understand innovation and to explore the multiple entities that are involved. Arti K is one of those scholars, one of the leading scholars in the country and indeed in the world on exploring how innovation happens, far beyond the patent context, to include basic science policy, to include the various processes of commercialization, to include new business methods like open source software. Her scholarship has been path-breaking. For about the past year, Arti was also someone who was at the US Patent and Trademark Office in the wonderfully named Administrator for External Affairs, which is second only to Keeper of the Privy Seal in being a fairly inscrutable title. So what you had there was a person who is perhaps one of the finest academic minds of her generation, studying innovation, in the nitty-gritty, the hurly-burly, put your euphemistic terms in there, of the Washington policy process, seeing how the various administrations, the various governmental entities that work on innovation work together. So here we have someone who is an abstract academic scholar of innovation, someone who studied it empirically, theoretically, legally, now put in the position to see the process from the inside. It is that dual perspective, to be both a person who is a keen student of the administrative process and also someone who is within it, and someone who is a keen student of the innovation process, that I think will make today's Frey Lecture so interesting, fascinating, and energetic. Arti Rai.
Well, thank you, Jamie, for that very kind introduction, and thanks to David Levy, my colleagues at Duke, and to Kip and Meredith Frey. To say that I'm honored to be delivering this lecture would be a significant understatement. In fact, I cannot imagine a more exhilarating experience. The title of the lecture is Innovation Policy, Theory, and Practice. That's clearly a huge subject, as Jamie has just suggested, and it may seem almost hubristic to tackle it. I have been hubristic enough to address the subject in some of my prior work as a scholar, and I have been hubristic enough to enter the fray of actually trying to implement innovation policy as the lead PTO patent policy advisor in the Obama administration. That work has impressed upon me the huge number of disparate federal funding streams and regulatory regimes that affect innovation, often without intending to do so. Sometimes these agency regimes work successfully. Perhaps more often, however, the vertical silos that these regimes represent can be unhelpful or even destructive. A systematic study of all of the different agency regimes would certainly fill a book, perhaps even a multi-volume series. I will try to be more modest in my lecture today, given the time constraints. I will illuminate my main concerns through two case studies that both involve intellectual property, fitting given that this is the 9th annual intellectual property lecture. These case studies, again, will draw both upon my experience on the ground, as it were, and on my work as a scholar. So more specifically, these studies will address the commercialization of federally funded research and the balance of IP protection and competition. I will conclude by arguing for a strong White House coordination presence in innovation policy generally, again, using the backdrop of these studies as illustrations of the need for such a coordination presence. But I want to start by doing a bit of framing. What do I mean by innovation? Jamie has already suggested it's very important, but I would like to get a little bit more detailed as to what I mean by it, and also a little more detailed as to why I believe it's important. So what do I mean by innovation policy? I think a bit of definition is actually key because innovation is such a buzzword and arguably, almost certainly in fact, an overused buzzword. In fact, it's such a buzzword that one could be forgiven for thinking it encompasses everything and therefore nothing. As an initial matter, I think it's very important to note that innovation policy overlaps with, but is distinct from, science and technology policy. While science and technology policy encompasses all policy issues raised by science and technology, privacy, free speech, and so forth, innovation is directly linked, in my estimation, to instrumental goals, most prominently economic growth. Additionally, innovation requires a product or process that is not only new technologically, but that also becomes widely and successfully diffused in a sustainable manner. So for better or for worse, much of what was done on Wall Street for the last decade or so would not, in my estimation, be innovation. With successful diffusion of innovation, we get the productivity gains that are the hallmark of innovation. To put the point another way, productivity gains through technical change drive economic growth. This is essentially the insight for which the economist Robert Solow won his Nobel Prize. This insight is now accepted by all major strains of economic thought. Solow's work was based on economic data from the US in the period between 1909 and 1949. More recently, Dale Jorgensen from Harvard, Bill Nordhaus from Yale, and many others have shown that the economic growth we in the US enjoyed from 1995 to 2000 was largely due to the diffusion of information and communications technology, ICT as it's sometimes fondly called. During that period, diffusion of ICT fueled a more than 2% average annual increase in productivity. So innovation is important in a very specific way, and even if it's defined very specifically, as I have thus defined it. Over the past few years, perhaps not surprisingly, the political branches of government have very visibly embraced innovation. As early as August of 2007, Congress passed what's known as the America Competes Act, which authorized significantly increased funding for the National Science Foundation, the National Institutes of Science, Standards and Technology, and the DOE Office of Science. These agencies conduct the type of science and engineering research that has been deemed by very influential members of the National Academy of Sciences to be particularly critical for innovation. In December 2010, Congress reauthorized the America Competes Act in a lame duck session that was otherwise riven by much partisan strife. And of course, President Obama spoke in his recent State of the Union address about our current era representing America's so-called Sputnik moment. So innovation is very prominent. And last but certainly not least, some of my good friends are now driving innovation within the Obama administration. The Obama administration has created a powerful White House position on the National Economic Council for a senior advisor for technology and innovation. The current occupant of that position is the superbly qualified Phil Weiser. Unfortunately, he doesn't put good high-resolution shots of himself on the web. So I apologize to you, Phil. President Obama has also created the first ever Chief Technology Officer of the United States position, which is located in the White House Office of Science and Technology Policy. This position is currently occupied by Anish Chopra, also superbly well qualified. Anish also knows how to put good high-resolution shots of himself on the web. So is there anything wrong with this happy picture? Two superbly qualified people, friends of mine, in the White House thinking night and day about innovation. My view, informed both by my scholarship and my recent experience, is yes. Unfortunately, as is often the case, rhetoric has outstripped reality. To cite just one example, the America Competes Act is only an authorizing statute. The actual money to double the research budgets of the National Science Foundation, the National Institutes of Standards and Technology, and the DOE's Office of Science has yet to be appropriated. It's 2011. This was authorized as of 2007. In addition, neither the NEC Senior Advisor for Technology nor the Chief Technology Officer positions are necessarily permanent. They could easily be eliminated in a subsequent administration. Moreover, while the portfolio of these positions is enormous, it includes not only innovation policy, actually, but also science and technology policy. These positions don't come with the significant cadre of staff that is absolutely essential, I believe, to manage such a wide-ranging and significant portfolio. I believe there are systemic factors that prevent innovation goals from being pursued in a sustained and coordinated fashion, or at least a sustained and coordinated fashion as we would like, within the US government. Some of these systemic factors become clearer if one looks carefully at a recent McKinsey report published just last month entitled Growth and Renewal in the American Economy. This report notes that from 2000 to 2008, we had productivity growth of 1.6%. Over half of this productivity growth came from the information and computer, and electronics sectors. However, even before the recession, these sectors had actually cut 4.5 million jobs. In other words, Facebook, Twitter, Google, and the like are terrific for growth, but they don't necessarily produce much in the way of jobs. We, as academics, may tend to view this job loss as a relatively short-term or perhaps even anomalous phenomenon. After all, as the McKinsey report itself points out, in every decade since 1929, overall productivity growth and job creation have been positively correlated. They've gone hand in hand. So perhaps this is a short-term anomalous blip. Or we may think the distributional question is a genuinely hard one, the fact that all of this money and growth isn't flowing to the middle class or the lower classes. But that it's unavoidable, and the way to address it is through progressive taxation and redistribution. We may even note, as some blog pundits have recently noted, that jobs and income are not necessarily the same as utility or happiness, and that the internet, for example, has brought much happiness to many people. As you might imagine, in the political arena, short-term job loss has a very different valence. And to push the point further, incumbent players threatened by innovation use it to justify the status quo. So the standard public choice theory that many of us have learned of incumbent players lobbying fiercely to protect their economic rents is enhanced by their very real ability to point to these 4.5 million jobs. I'll address that issue more in a moment. What other challenges might we see to sustained and coordinated action on innovation? Well, although innovation is generally thought of as a bipartisan issue, once we get into the details of how it should be promoted, ideological fissures do emerge, perhaps not surprisingly. For example, to what extent should government really play a role in fostering innovation? Do we really need coordinated government policy? Isn't that industrial policy of the sort that countries like China engage in? Some well-accepted inputs to innovation include some of the following: higher education attainment, science and technology researcher intensity, research and development funding, both government and corporate, information technology infrastructure, responsible capital markets, and the like. We can go down the list. Most of these are probably familiar to many of you. However, with respect to many of these, there will be political arguments about the appropriate government role. For example, even with respect to something we may think is fairly non-controversial, like basic R&D funding, R&D funding. So this input right here. Once we get towards the non-basic end of the spectrum, to the more commercially viable end of the spectrum, we get debates about whether the government is, quote, picking winners and losers, unquote. In this regard, it's worth analyzing the innovation pyramid that's put forward in the recently updated Obama Strategy for American Innovation, produced by Anish and Phil and others in the National Economic Council, OSTP, and Council of Economic Advisors. The top tier in particular could get quite controversial. Catalyzing breakthroughs for national priorities. Well, who determines what's a national priority? Is this picking winners and losers, in terms of green energy, biotech, nanotech, and the like? I must admit that prior to going into government, I underestimated the force of that objection, the industrial policy objection, but it is huge, particularly, again, because of the perception that this is what China is doing, and we don't want to put forward to the world a model that imitates China's. And perhaps needless to say, industrial policy objections are likely to be incredibly vociferous when one is talking about spending federal money in the current debt crisis. So before I get into the case studies, let me sum up what I see as the three key challenges to sustained and coordinated action on innovation. Responsibility is dispersed across many agencies, many of which have missions not squarely focused on innovation, almost all of which actually have those missions. We don't have a Department of Innovation in our US government. Innovation can threaten powerful incumbents who can rely, particularly these days, on credible arguments about jobs. Government promotion of innovation can be seen as industrial policy. As I said, I'm going to be fleshing out these case studies in two IP-related contexts. These are both going to be patent contexts. Patents is my primary area of expertise. However, as you can well imagine, some of these impediments are even further magnified in the context of, for example, copyright. So, commercialization of federally funded research. The federal government invests extremely heavily in research, R&D, $144 billion, that's billion with a B, in fiscal year 2010. As a comparator, US corporations did about 230 so billion with a B of R&D in the US in fiscal year 2008. So almost as much as the private sector within the US at least. US corporations also do a lot of R&D overseas. So many significant investments in R&D. Many different agencies also fund R&D. There's a whole alphabet soup of them, dozens in total. Particularly significant are the Department of Defense, the Department of Energy, NASA, and NIH. Those four represent about 90% of the total. The Recovery Act, which was something that was implemented in the first few months, of the Obama administration, has had an additional $100 billion or so. Now, commercialization of this research is largely governed by two statutes, Bayh-Dole for research conducted by external grantees, and Stevenson-Weidler for research conducted within the government, primarily within our national labs. These are largely parallel in structure, and I'll focus on Bayh-Dole. These are some flattering pictures of Birch Bayh and Bob Dole taken about the time the act was written, which was 30-some years ago now. I put up their pictures because they're known fondly or not so fondly as the, quote, framers, unquote, of Bayh-Dole. And I use framers advisedly because Bayh-Dole in some circles has an almost constitutional status. Bayh-Dole originated in the late 70s in the midst of a situation perhaps not too dissimilar to that in which we find ourselves today. In fact, it was a revelation to go back and reread some of the legislative history given our current economic situation. The legislative history very prominently points out over and over and over again, evidence is mounting that the United States is falling behind its international competition in the development of new products and inventions. The report also emphasizes, again, strange case of deja vu, that the key factor behind the US's economic problems is the decline in technological innovation. And it cites a study attributing 45% of economic growth between 1930 and 1960 to technological innovation. Then it makes a further move. It says that the decline in technological innovation can, in significant part, be traced to federal agencies putting all this money into R&D, billions and billions even then, and not bothering to determine whether it becomes commercialized. The report also emphasizes the 24 different agency policies in place regarding patent ownership and the complete inability for grantees as a consequence to determine how to commercialize if they want to do it. There, I think Bayh-Dole actually got it right. We very much needed uniformity among agencies, so this is a theme that has been with us for a long time. Bayh-Dole implemented uniformity by conferring the rights to file for patents on grantees, mostly universities. In the view of the Bayh-Dole framers, grantees that sought patents, would then have a financial incentive to commercialize the patents through licensing. They would get money for the licenses and therefore would have an incentive to seek those licenses and get the products commercialized. Now, reasonable minds can differ, and many of us on the faculty here have differed, about whether patents and licensing are always necessary for commercialization. But one advantage they do provide is a paper record. They do provide a mechanism by which scholars can go back and check to see whether there has in fact been technology diffusion, and as a consequence they can, at least in theory, promote accountability. In fact, the language of Bayh-Dole was quite prescient in trying to establish this paper record. Specifically, for example, it requires that all grantees, those who receive federally funded research, put in the patents that emerge from that research a government interest statement saying the research was developed with government funds. This is an example of a government interest statement in a Group B streptococcus vaccine patent owned by Harvard. The legislative history makes it clear that this government interest statement is meant to alert the private sector, including potential defendants in lawsuits, of the possibility that the patent owner may not be commercializing appropriately. And in that situation, so the legislative history points out, the third party can go to the government and say, hey, this patent is not being commercialized appropriately. Go ahead and march in, as the statute provides, to take back the rights and force commercialization. Unfortunately, research I've done together with Bhavan Sampat of Columbia strongly suggests that there's significant underreporting of government interest statements. And this is where we, the universities, bear the blame. For example, out of more than 26,000, academic biomedical patents we studied between 1977 and 2007, only 43% of these academic patents have a government interest statement, and this is during a time when approximately 2/3 of academic life science research was federally funded. So there's a discrepancy right there, a prima facie suggestion right there of underreporting. More generally, even independent of march-in, Bayh-Dole required that federal agencies be notified of patents and licenses so they could keep tabs on what was going on. Here, the grantees, primarily, again, universities, were supposed to report into a database called Edison what they were doing with their patents and licenses. We believe, Bhavan and I, that there's significant underreporting here as well. It's harder to know definitively because the Commerce Department, which has rulemaking authority under Bayh-Dole, in its infinite wisdom, decided back in the early 80s to make this database completely off limits to researchers. So it's completely secret. How did we get this 30% figure here? We think there's only about 30% of academic biomed patents are reported in Edison. Well, very recently, NIH has sucked out some of the data from Edison and said that this is what we think is reported in Edison with respect to our patents. So that's why we think there's significant underreporting, not simply to the outside world, but also to the government itself. And obviously, without reporting, we can have no sense of whether commercialization is working, let alone about accountability. So it's perhaps not surprising, let me go back, that federal funding agencies are failing to do a careful accounting. But Bayh-Dole did put in some specific safeguards that agencies were supposed to implement so as to ensure that universities were not engaging in inappropriate exercises of discretion. Unfortunately, even those minimal safeguards have not been implemented, and I think we're pretty far from an appropriate level of oversight. One small step, by the way, towards more oversight would be simply to open up Edison, this very secret database, at least to some degree. This could be done simply by reversing one ill-advised Commerce Department regulation. But here we see the power of incumbents at work. At a certain point in my tenure last year, a rumor spread that the Department of Commerce, together with the White House, was thinking about tinkering, maybe a little bit, with Bayh-Dole regulations. The rumor was actually not even true. And subsequent public meetings with universities have made that clear. The White House and the Commerce Department simply want to, as should be obvious, do better in terms of measuring reporting, commercialization, and ultimately economic growth as a consequence of federal funding. But even that rumor was sufficient to elicit threatening responses from a variety of universities. That said, the very fact that an inquiry into commercialization of federally funded research is currently being undertaken by the White House and the Department of Commerce does show that the White House can be a very important catalyst. I think it's fair to say that without the White House pushing, such an inquiry would never have gotten off the ground. However, I do think, and I'll discuss this more in a moment, that the White House can and should do more. The fact is, Edison, 2 years into the Obama administration of open government, still isn't open. I want to turn briefly to another area where we see agencies facing significant limitations, such that White House involvement is important. And this is the balance of IP protection and competition. One long-running, even classic, one could say, debate in the literature on innovation involves whether IP protection or competition is better for innovation. Similarly, in the US government, we have the so-called protection agencies and the so-called competition agencies. They don't self-designate this way, of course, but I think we can put them in categories such as these. As you might imagine, the PTO, the Copyright Office, the US Trade Representative tend to fall on the protection side of the ledger. The DOJ, Antitrust Division, the FTC fall on the competition side. Again, this is a bit of a caricature. I would say the PTO in particular, where I worked, has the potential to very ably represent both protection and competition, and its current leader, Dave Kapos, very much understands that balance very well. And he's done a great job of doing lots of things on his own to make sure the patents are relatively high quality and narrow in scope. The PTO has also hired a chief economist, Stu Graham, who, for the first time, the PTO now has economic authority to, or economic expertise, and really understands concerns about overly broad patents. Conversely, the FTC and the DOJ have many economists who understand the importance of patents to innovation. Even so, there is some tendency on both sides towards a silo mentality, and I think that because of that, the White House can play a critical role as honest broker in certain cases. One example of a case where I think the White House appears to have played such a role recently is in the context of a challenge by the ACLU to the patentability of genes. As some of you may know, in a reversal of policy, the US government recently filed a brief stating that certain types of DNA sequences should not be patentable subject matter. The brief specifically notes the interest of many different agencies in this case, and it would appear that there was some sort of convening role played by somebody, probably the White House, to get that interest, the respective interests collated and combined to a single brief. Now, I actually don't agree with the specifics of the ultimate USG position, but I do think there's a genuine innovation-related question to which the position is attempting to respond. In general, as many of you probably know, one concern we have about having lots of patents in a given area of research, a concern to which Jamie has already alluded, is that the transaction costs of licensing may be problematic for subsequent innovators in that area. In other words, a patent thicket may arise. With the advent of so-called whole genome sequencing in the genetics arena, there is a serious question about whether gene patents could produce a patent thicket down the line. And as is typically the case with potential IP thicket problems, the potential innovators who could face these problems are not well represented in Washington. In fact, they may not even exist. Certainly, they don't have any significant lobbying clout. By contrast, incumbents who can brandish concerns about jobs are well represented. But in this case, at least in terms of the US government brief, which again, I don't agree with the specifics of, but nonetheless think is very interesting, the incumbents did not win, and that's interesting. I think that suggests that the White House played a very interesting role in this case. Again, however, there is room for improvement. With more leadership and staff in the White House, I think we might ultimately have gotten to an even more subtle position on the question of gene patents and thickets. Perhaps a position similar to my own, but in any event. Additionally, the ACLU case is a little bit sui generis because it receives so much media attention. There are many other cases in which the silo mentality persists, and unfortunately, the White House personnel, talented, superbly talented as they are, simply don't have the staff to address all of them. And so there's no reasoned resolution of interagency silo mentality in those cases. So prescription, this is always the hardest part, right? And before I went into government, Professor Benjamin and I decided to do the ultimately hubristic thing and come up with prescription for this set of problems. We proposed creating a White House Office of Innovation policy that would be similar to an office that currently exists within the Office of Management and Budget That office, very little known to those who are not inside the Beltway, but very much known to everyone inside the Beltway, is called the Office of Information and Regulatory Affairs. This is the regulatory czar, if you will. That office is currently headed by a very prominent former academic by the name of Cass Sunstein. This office has the ability to, with respect to any significant agency regulation, basically stop it. Because the office deems the benefits of that regulation not to exceed the costs, or to put it more articulately, the cost of the benefit to exceed the the benefits of the regulation. So we propose, Professor Benjamin and I, that perhaps there should be an Office of Innovation Policy that, with respect to any significant agency action, could have the ability not to stop. We think OIRA perhaps has too much power, but at least to delay so that the OIP could analyze the regulation to determine whether, on balance, there was a less innovation-depressing way to promote whatever objective was at issue. So whether the objective was regulating risk or anything else one can think of that might create problems for innovation, the question would be, could we do it in a way that would be less harmful to innovation? This office obviously has not gotten off the ground. That said, OIRA has taken on the innovation message very deliberately, and just a couple of months ago, President Obama issued an executive order saying that all regulation should be re-examined for a variety of impacts, including very prominently innovation impact. And I think it's fair to say that some of us did a lot of proselytizing along those lines. So this is good. So I think that's progress. This new OIRA order is progress. There are a whole suite of organizational approaches suggested in a recent Center for American Progress report, which I would commend to your attention. It just came out last December, and it's authored by John Podesta, who has some experience in Washington circles. He was the chief of staff to President Clinton. He points out, and I'm heartened that this has come up so prominently in a report by such a prominent person, that irrespective of one's substantive disagreements about innovation, how much government should play a role, how much government should not play a role, what really fosters innovation, what does not, and even, is innovation such a worthy goal to be pursued in the first place? The structure of our government is not conducive to any kind of rational policy on innovation. The president's structure, this is a quote from the report, the president's structure of the federal government's economic policy apparatus is not conducive to the formulation of the cohesive long-term blueprint this country really needs, or clearly needs. And what he's basically talking about is long-term economic thinking, i.e. innovation. Now he proposes abolishing the Department of Commerce and essentially creating a department instead of long-term economic competitiveness. I'm not John Podesta, I can't go that far, but I think it's really important that policymakers read that report carefully and think carefully about what we might need to do that is perhaps somewhat radical in terms of prescription. So, in closing, I can say that I'm very glad to have entered the fray for a while. It was a very illuminating experience for me as a scholar, and it makes it clear to me that I have had a lot to learn about the way the world operates, and I hope to use that learning in my scholarship going forward. I also should say that there are some extremely talented people in government. Phil and Anish are two of many, and it's astonishing that people like that go into government. And I would encourage many of you, despite some of the negative things I may have said, to think about it, because it is the future of our country, and I apologize for the cliche, but it is the future of our country. Having said all that, I am very glad to be back in paradise. And this is paradise, so thank you very much. Sure.
Well, we have time for a couple of questions, if anybody has them.
So, Arti, that was wonderful, fascinating.
But as you said, this is paradise, and so someone has to be the serpent. You mentioned some of the ways government can get innovation right, and you mentioned some of the ways you can get it wrong. One of the ways you talked about was regulatory capture, particularly problematic in the innovation field because frequently the counterbalance to the established interests haven't yet been invented, and the established interests get to strangle them in their crib before they are, before they're born. So it's just a wonderful, situation where you don't even have, weak, up-and-comers, incumbents. The industries don't exist. In that context, do you fear that centralized innovation policy in the White House might just be wonderful because it would only a single place we have to capture? And in particular, do you think, having given your own experience, that actually the United States has frequently been well served by the utterly chaotic, contradictory, almost feudal fiefdoms in which innovation policy is well served, so that NIH is off by itself doing its sort of, science-y thing, and over here the FTC, has never seen a monopoly that it likes, and over here the PTO at least used to, and never seen one that it didn't. And the combination of those views, though if you take them individually seems ridiculous, actually has the process of keeping a set of things on the table, which if you had an administration more closely linked to, say, a certain set of economic interests, or let's say a president or vice president with connections to certain industries, a particular voice might dominate.
So, as always, Jamie, a great question. So, is the pseudo-Hayekian, if one can even put it that way, perhaps structure of our government with respect to innovation better because decentralization of innovation policy within the government is the way to go, lest we otherwise face capture or very easy capture? So a very fair question. I think that as a practical matter, it may be the case that it would be easier to capture say, White House Office of Innovation Policy, but I doubt it. And here's why. There are particular nodes of government structure that already have been determined to be the places one goes to capture the real decision-making apparatus. So I don't think, in some respects, it could get much worse. That's one. Two, and the fact is that the well-heeled incumbents have, it seems, an inexhaustible supply of people and PowerPoint presentations and the rest of it. So, having to capture a few nodes is just not that difficult in the current structure. Second, and perhaps this is a little bit idealistic and based upon the current occupants of some of those innovation-related positions in the White House, the idea would be to set up a structure that would attract people who are inherently less subject to capture. And how to do that is an open question to some extent, but that would be the idea. Look, the FTC may not have met a patent it didn't like in the past, but now it likes patents a bit more, and in general, God knows why the FTC has never been captured by anyone, as far as I can tell. There's something about the FTC that forbids it from being captured, and so I don't think it's impossible to set up an institution that can't be captured.
Arti, great job, and it's great to have you back around. So this question presses in the opposite direction in some ways from Jamie's. So Jamie talked about your humility, and then you talked about your hubris. But I was actually struck not by your hubris.
So I'm just right?
No, not by your hubris, but by your humility. At a couple of points where you could have, and I thought one might call for something very sweeping, you stopped at the edge, and I couldn't quite tell why you stopped. So I want to ask you to elaborate a little more on your reasons. I'm thinking of two moments in the lecture. One where you said industrial policy, picking winners, trying to take the country's economy in a direction. But we don't want to show the world a face that looks like China. And then we go on. So I want to know more about what that reasoning is.
That's not necessarily my argument. That's the
argument. So you're merely reporting a political. Then I want to know your view of that.
Okay.
Two, a sweeping revision of the federal government structure. Answer, I'm not John Podesta. But
fair enough.
Yeah.
But I'm not.
You're already right.
There's something better. So I want to know what Arti Rye thinks about both of those.
All right, so I'll take the second question first because it's a little bit easier, the second example first. I don't think even John Podesta thinks he's going to accomplish that. He's putting that out there. I don't have any inside information, but I don't think even Podesta, I think he's putting that out there as just a trial balloon to see how much people squawk. Or I'm mixing my metaphors, trial balloon to see how quickly it goes down. And so, yeah, I mean, I could put out a trial balloon of let's reorder government entirely. Ain't gonna happen. You know, all that said, maybe I should do more in putting out the trial balloon. And, you know, I'm going to invoke Professor Benjamin here as well, have thought at various points about that. But it's really, to reorder bureaucracy in any sort of fundamental way is very, very difficult. On the first question, that's actually a tougher and in some ways more interesting, to me at least, question. For this reason, and this is why I'm reluctant to espouse my own opinion at this point. It's not entirely clear to me exactly what China is doing. So it's well beyond the age of the 5-year plans of industrial policy. I mean, it's much more sophisticated than that. And it seems to me that if what China is doing is what I've heard some people say, which is very sophisticated and somewhat actually not decentralized exactly, but driven by scientists as opposed to bureaucrats, then it could be a very interesting and actually threatening model, threatening for the US. But I don't know enough, and I think it's very hard, given the opaque nature of the Chinese bureaucracy, to know enough to know exactly what they're doing.
Jerry.
Well, a couple of things. I think that your insight about OSTP is empirically correct. That is, during the database wars, it is a place where the academies, for example, can directly interrelate, and the science agencies can directly.
So this is the Office of Science and Technology Policy, which is an office within. I was actually talking about the FTC, but OSTP is also represents an example of an office that, as far as I can tell, has not been captured.
So the point hasn't been captured, and I think it didn't have sufficient power, but it is a place where all these other interests that aren't captured in the basic research input side have a place to go. So if you strengthened it, made it part of the policy, I think it would work. I would also say you need to consider on the question of picking winners, or not only what the Chinese are doing, which I'd say we don't know, but they may actually be doing what Rockefeller did in the heyday, was just picking good people and giving them lots of money and not putting on a grant basis, which is the most successful epoch of granting we've ever seen in the United States, was that method. But the Koreans are picking winners very well and have been doing it for about 30 years with their Central Science and Technology Agency, in which the people who actually make the winners are forced to move out and put it in practice. It's another interesting thing. My question is, in your studies, which I think are wonderful and illuminating and on the right track, my question is, what thinking has been given to the fact in relation to jobs that so many of these innovations, which were by-doled, actually end up being applied in abroad, and the jobs go there, and the jobs haven't been here, even though the Act is supposedly has some measures against it, which are GATT inconsistent. But I don't think it's a matter of. I don't really think it's a matter of legal provisions. I think it's a matter of some basic flaws in our economic apparatus. I wonder what thought it is. I mean, if those I can think of a whole bunch of them that, had they been developed here, we would have had millions more jobs, and I don't understand why they weren't developed.
So let me just quickly make one footnote on about OSTP. So OSTP is an obvious example of a place where, and actually Anish is located in OSTP, nominally at least, that could eventually become a type of nucleus, or be the nucleus for an innovation policy office. OSTP has historically been extremely weak. And I think, unfortunately, at some point, if you've historically been so weak for such a long time, it's hard to break out of that that perception. So NEC some spin-off of NEC. Actually, the Podesta report suggests a permanent deputy within, or deputies within NEC for innovation and competitiveness. That would be a better place, I think, at least sort of on first examination to think about putting the White House apparatus that I'm proposing, or we're proposing. On the Bayh-Dole piece, I'm not aware of technologies that would have generated millions or billions of dollars that were developed abroad. There is in Bayh-Dole a prohibition on licensing to foreign entities. And so you're supposed to get exemptions if you do that. And in fact, some of the major dust-ups around Bayh-Dole have surrounded situations where there was alleged licensing to foreign entities. So that is not a sort of a point of view that I've seen, or that assertion doesn't seem to be borne out by what at least I've studied. That said, it is true that obviously a lot of companies are doing their R&D abroad. I think that's mostly due to lots of reasons that have nothing to do with Bayh-Dole, but some have argued that the university tech transfer officers are such a pain to deal with that it's easier to deal with foreign universities, quite frankly. And actually, not some have argued, the Thursbys, Jerry and Marie Thursby, have done a very nice survey published in Science in 2003 that suggests that's one factor that R&D heads at multinational companies consider. It certainly is the case that that it's a disincentive to do business or do R&D in the U.S., the intransigence of some university tech transfer offices.
Thank you, Arti.
Produced by Duke University. Online at duke.edu.